Assalamualaikum and hi everyone. This scenario is about a conflict between Argentina and its region Viloria. The central government took control over Viloria's natural resources and Viloria didn't agree with that. They said it was unconstitutional. Because of that, things got tense. When negotiation failed, Viloria went ahead with its own referendum. Most people voted for independence and they declared themselves separate from Argentina. After that, Novak recognized Viloria and even sent in military forces, but other countries still supported Argentina. This led to armed conflict and Viloria's leaders ended up forming a government in exile. So, for the discussion today, we will focus on whether Viloria can be considered a state and also whether Novak's military action is actually legal. So, let's move forward.
Good day, my name is Alina. I will address the first issue on whether Viloria can be recognized as a state under international law. To answer this, we must understand statehood requirements. In international law, an entity must have legal personality, meaning it can hold rights, assume obligations, and participate in international relations. Now, how do we determine whether Viloria qualifies as a state? We apply the criteria in the Montevideo Convention on the Rights and Duties of States, which sets out 4 requirements. First, a permanent population, meaning a stable community of people with no minimum size. Second, a defined territory, referring to a physical area under control even if boundaries are not fully settled. Third, a government that exercises effective control over the population and territory. Finally, independence and the capacity to enter into relations with other states, meaning the entity is not under another state's control and can conduct its own foreign affairs. At this point, we may ask, is declaring independence enough? The answer is no, as shown in the Alan Islands case where effective governance was required for recognition. Under the declarative theory of statehood, an entity becomes a state once it meets the objective criteria, regardless of recognition by other states. This was also reflected in the Kosovo Advisory Opinion, where the court held that declarations of independence are not prohibited but do not automatically create statehood. Therefore, Viloria can only be considered a state if it fulfills all of the aforementioned requirements and not merely through declaration. With that said, I will now pass the floor to Anis.
Viloria International Legal Personality will depend on Article 1 of the 1933 Montevideo Convention, which are permanent population, a defined territory, effective government, and capacity for international relations. First, Viloria meets the population criterion. Its residents, which are formerly Argentinians, form a permanent population in the Viloria region. Much like Nauru, where a small population suffices for statehood, nationality presumptively shifted to Vilorian absent prohibiting treaties. Second, it claims a defined territory. Though Argentina contests this, Viloria's independence declaration established effective authority over a clear area until Argentina post-war occupation loosened its control. Third, pre-independence, Viloria's government protested resource exploitation, showing inherent power akin to DRC case. However, post-declaration war, it collapsed into exile, failing the effective government test per the Alien Island case, where control recovered only after the conflict occurred. Finally, Viloria's Norfolk Agreement signals capacity for relations, proving initial sovereignty. However, after the war had occurred, the war-induced instability, leader exile, Argentine dominance, and lack of recognition echoing Biafra constitutive theory to be filled. To conclude, Viloria does not qualify as a state under international law.
The issue is whether the overt deployment of troops and military advisors into Viloria is lawful under international law. So, under international law, state responsibility arises when a state commits an internationally wrongful act. According to the International Law Commission draft to the Article 2001, this occurs when the conduct is attributable to the state and breaches an international obligation. Here, the relevant obligation is found in Article 2, Clause 4 in United Nations Charter, which prohibits the use of force against territorial integrity or political independence of another state. This prohibition is broad and not includes not only direct military intervention but also indirect form of intervention such as military support and advisory involvement. This was clearly established in Nicaragua, United States, where the International Court of Justice held that intervention is unlawful when it involves coercion in another state's internal affair. The court also emphasized that indirect actions such as providing training, intelligence, or logistical support still amount to breach of international law. Furthermore, the presence of foreign troops is generally unlawful unless there is valid consent from the legitimate government of territorial state. This consent must come from a recognized authority, not from disputed factions or groups lacking in legal standing. This principle was reaffirmed in Democratic Republic of Congo and Uganda, where the court found that Uganda military presence violated both sovereignty and prohibition on the use of force. Importantly, the court rejected argument based on security or stability as sufficient justification. In addition, without valid consent or another recognized exception such as self-defense, such intervention will constitute a breach of international law and engage with state responsibility.
Now, I will explain why Novak's military intervention in Valoria may be considered unlawful under international law. First, it is important to determine whether Valoria has the legal authority to allow Novak's troops to enter its territory. Under international law, only a recognized state or lawful government can give valid consent for a foreign military presence. Although Valoria declared independence and received recognition from Novak, many countries still recognize Argentina as having sovereignty over Valoria. Therefore, Valoria's status as a state remains unclear and disputed, making its consent legally questionable. Secondly, Novak's action of sending troops and military advisors into Valoria may amount to a use of force under Article 2, Clause 4 of the United Nations Charter. Since Valoria is still widely considered part of Argentina, Novak's military presence can be seen as interfering with Argentina's sovereignty and political independence. Furthermore, in the Nicaragua case, the court stated that the unlawful intervention does not require a full military intervention. Even providing military training, advice, or assistance to one side in a conflict may amount to illegal intervention if it influences the internal affairs of another state. In this case, Novak's support for Valoria clearly affects the internal conflict within Argentina. Lastly, the case of Democratic Republic of Congo versus Uganda shows that foreign troops' presence without valid consent violates state sovereignty. Similarly, Novak may be internationally responsible for breaching Argentina's sovereignty and using unlawful force. In conclusion, the deployment of Novak's military troops and advisors is unlawful under international law.
Overall, Novak's development of military troops in Valoria is unlawful under international law. At the same time, Valoria does not fully qualify as a state, even though it declared independence and received some recognition. From this conflict, we learned that recognition alone is not enough to create a state, and any use of force must strictly follow international law. This situation also shows how complex issues of sovereignty and legality can be in international disputes. I think that's all from us. Thank you.